A criminal conviction is not the end of the road. It's often the beginning of the appellate process. I'm Professor James Mitchell, criminal appellate specialist and law professor, and I'm going to show you how to challenge wrongful convictions and pursue every available remedy when the system fails. Criminal appeals in New York follow different rules than civil appeals, with shorter deadlines and more limited grounds. But understanding these procedures can mean the difference between serving an unjust sentence and winning your freedom. You have 30 days from sentencing to file a notice of appeal for most criminal convictions. This deadline is jurisdictional. Miss it, and your appeal rights are gone. Unlike civil cases, there's generally no extension available, so calendar this deadline immediately after sentencing. But here's what many don't understand. Your right to appeal depends on how you were convicted. If you went to trial and were convicted, you have an automatic right to appeal to the appellate division. If you pleaded guilty, your appeal rights are severely limited unless you preserve specific issues. Conditional pleas under CPL 220.30 let you preserve appellate rights while pleading guilty. You must get court approval and specifically identify the issues you want to appeal. Common preserved issues include suppression motion denials, jurisdictional challenges, and constitutional violations. For direct appeals, you're limited to issues that appear in the record or were properly preserved at trial. This means your trial attorney must have objected contemporaneously to preserve most issues. Failure to object generally waives appellate review except for rare fundamental errors. Ineffective assistance of counsel claims require showing both deficient performance and prejudice. The standard is high. You must prove counsel's performance fell below objective standards of reasonableness and that competent representation would have changed the outcome. Most ineffective assistance claims fail because courts give great deference to strategic decisions. Failing to call witnesses, not pursuing certain defenses, or plea negotiation strategies are usually considered tactical choices, unless clearly unreasonable. But some errors are so egregious they constitute per se ineffectiveness. Complete failure to investigate, sleeping during trial, or operating under conflicts of interest. These don't require showing prejudice because the right to counsel was constructively denied. When direct appeals fail or weren't available, CPL 440 post-conviction motions provide another avenue for relief. These motions can raise issues not in the trial record, including newly discovered evidence, constitutional violations, and jurisdictional defects. CPL 440.10 covers motions to vacate judgments. Common grounds include newly discovered evidence that would probably change the verdict, constitutional violations that weren't previously raised, and jurisdictional defects that void the conviction. The newly discovered evidence standard is extremely difficult to meet. The evidence must be material to guilt or innocence, likely to change the verdict if presented at trial, not cumulative to evidence already presented, and not discoverable through due diligence before trial. DNA testing has revolutionized post-conviction relief. CPL 440.30 allows DNA testing. When identity was an issue at trial, testing wasn't available during the original proceedings, and results would establish a reasonable probability of innocence. Actual innocence claims under CPL 440.10 require new evidence that is of such character and weight that it would probably change the result if offered at a new trial. This is an incredibly high standard, but it's been met in cases with DNA exonerations and recantations by key witnesses. Federal habeas corpus provides another layer of review after state remedies are exhausted. Under 28 U.S.C. 2254, federal courts can review state convictions for constitutional violations, but only after you've pursued all available state remedies. The Anti-Terrorism and Effective Death Penalty Act severely restricts federal habeas relief. You generally have 1 year from the conclusion of direct review to file, and federal courts can only grant relief if state courts unreasonably applied clearly established federal law. Procedural default rules can bar federal review if you failed to raise issues properly in state court. There are narrow exceptions for cause and prejudice or actual innocence, but these are difficult to establish. Here's my strategic advice for appellate practice. Start thinking about appeals during trial. Preserve objections to every adverse ruling, create a complete record of constitutional violations, and ensure all motions are properly briefed and argued. For post-conviction relief, timing is critical. Many CPL 440 motions must be filed within specific time limits, and delay can be fatal to your claims. Gather new evidence quickly and file promptly once you have grounds for relief. Don't pursue frivolous appeals or motions. Courts remember lawyers who file meritless claims, and it hurts your credibility for legitimate issues. Focus on your strongest arguments and present them persuasively. Remember that appellate and post-conviction practice requires specialized expertise. Criminal trial skills don't automatically translate to appellate advocacy. Consider hiring appellate specialists for serious felony convictions with viable issues. The statistics are sobering. Most criminal appeals and post-conviction motions fail, but when they succeed, they can restore freedom to the wrongfully convicted and correct fundamental injustices in our system. Mediator Kim will now show you how to navigate plea negotiations and alternative resolution programs that might avoid the need for appeals altogether.